let me ask you, what title does your land have? Do you have a land in Lagos or some other place in Nigeria? Well, today we're looking at land titles, as a report says 94% of lands in Lagos lack legal titles. Is that true, and why is the case so? We have with us in the studio Victor Jibunoh Esquire, who is a lawyer in Lagos and is also managing partner and head of corporate, commercial and general legal services at OPTIX Legal Consulting. Good morning. Welcome to the show.
Yeah, good morning.
Let's begin with the report that says 94% of lands in Lagos do not have legal titles. First, let's understand what legal title for a land would mean and look at the report. Do you think it's true? 94%, that's almost like all the lands in Lagos.
Anyway, when I got the report, I wasn't surprised because a lot of properties, lands in Lagos, most of the landowners there don't have legal titles. So you see majority of them, when they want to purchase a land, you see them just coming up, approaching a lawyer to just do a deed of assignment and just think that that's the end of it, that you have a legal title. Of course, a deed of assignment creates a legal interest, but it's not just you preparing a deed of assignment. There are stages. It is until when that deed of assignment becomes perfected, perfection, that is what actually gives it the legal strength as a deed of assignment. And when you're talking about perfection, you're talking about doing the governor's consent. You're talking about doing the stamping and registration. So once you do that, you've perfected your legal interest with respect to a property which you bought.
So this seemed like a very long process, but what legal title ideally should a land have?
Yes, I wrote an article on understanding the various titles, legal titles you can have on a land. So there are various type of legal titles you can have on a land. You have the certificate of occupancy, which is usually issued by the state government. Okay, so you have the governor's consent. Now, the governor's consent is usually issued where that property already has a certificate of occupancy, so you don't need to apply for another certificate of occupancy. What you just need to do in order to transfer that certificate of occupancy to a subsequent purchaser is just for you to do a governor's consent, to let the governor to be aware that this certificate of occupancy, which has been issued by you to me, I want to transfer to some other person. So just do a governor's consent. And the governor's consent is also a legal title. You also have excisions and a gazette. Now, excisions and gazette has to do with where the government, the state government in this case, is trying to is returning a land back to the indigenous owners of that land. So what they do is to do a gazette. Now, if you have a gazette, it gives you a legal title. It gives you a legal title. Then you have registered court judgments. There are cases where you see two disputing parties with respect to a land having two different titles to that land. But at the end of the day, when the court determines who is the rightful owner, it gives a judgment and registers that judge. It gives a judgment with respect to who is the real owner of that property. And what you just do is take the judgment to the Ministry of Lands to register that judgment. It gives you legal title. Then you have right of occupancy as well. It's a right, a legal right given to a landowner by the government to use the land for 99 years. And so a lot of legal titles that you can have on a landed property, not just C of O or governor's consent. A lot of people don't know about this.
Let's harmonize this so that our viewers will understand better. The general perception is once you have the C of O or the deed of agreement, you have the titles to the land or to the property. But give us a better orientation. Must you have more are there other documents that must be in possession of the owner or the supposed owner of the property apart from C of O, or must you have more
Oh, okay.
Maybe it's just one that will qualify you to have the titling, or you need to have more documents. And if you need to have more, what are these documents?
Very well.
What's the number of required documents?
Okay.
Talk about minimum or the maximum,
Okay.
if that exists.
On the particular piece
Yeah.
of land. Just one of them will suffice. You don't need to have 3 on a particular piece of land. Just one, it suffices.
Looking at the legal weight, which one will come first if you're talking about all these documents?
Well, in my article I wrote with respect to the various titles you can have on land, I made a comment that, of course, the most valuable form of title that you can have is the certificate of occupancy. Okay, so that's the reason why you see most people always want to say, I want to do C of O on my property, I want to do C of O on my property, but that does not take away the fact that other titles, which I just mentioned earlier, valid legal titles to that property.
In the case of CFO, Lagos is recorded poor when you talk about the number of lands with CFOs in Lagos State. So the first vice president of the Nigerian Institute of Estate Surveyors was talking, and he mentioned that across some states you find that the number of those lands with CFOs are quite low. Surprisingly, Lagos. But a surprise also came along the way to know that Edo State, since the state was created in 1991, had up till the administration of the current governor, Governor Godwin Obaseki, had about 2,000 CFOs. But in 8 years, the state has recorded about 30,000 CFOs. Now, what is the bureaucracy about the assignment of CFOs to land? Why is it such a struggle, a difficulty for landowners to have CFOs?
Okay, we are looking at Lagos, right? Now, the first thing is that, Lagos is a commercial city, and, being a commercial city, commercial hub of the country, a lot of people see having landed properties in Lagos as an opportunity to make money. So there is always this competition on landed properties in Lagos. So that's the first thing. And the next thing is the issue of litigation. We have a lot of litigations on landed property. When you go to the land registry to search with respect to the validity of the title of the person who proposes to be the owner, you see there are a lot of encumbrances on that title, which he is also claiming he is the owner. So you see, the issue of litigation is one of the reasons why it is always difficult for property owners to be able to get these legal titles on these properties, because once there is a litigation on that land, the government cannot issue any title on that land, because there is a dispute which has to be resolved before the government can issue a legal title on that landed property. Then we also talk about the bureaucracy that has to do with the process involved in getting this documents, these legal titles to the land. Even by the time you prepare a deed of assignment, and you want to perfect to get a legal title, you have the governor's consent. It takes a lot of bureaucracy for you to get the consent from the governor. It takes a lot of time. They're not talking about issues of 1 year. It takes a lot of time to get this governor's consent. What about the stamping? It takes a lot of time to get the stamping done and the registration at the end of the day. So you see a lot of bureaucracy involved in getting this legal title. So I'm not surprised if the statistics is saying that over 94% out of 100 don't have legal titles to land in Lagos. So these are the issues.
You'll be wondering if an urban city like Lagos is having this kind of experience. What will happen in the remote areas or villages? But the issue is it transferable when you talk about legal titles? For instance, if I have a property or I have a piece of land and I have to sell to Blessing, for instance, the legal titles that I possess, is it transferable? Are they transferable, the documents? And if that should be done, what are the processes that should be put in place to ensure that she becomes the valid owner?
Yes. Of course, those legal titles, like I said, they are transferable. Like I made an instance of why you may dispense with a C of O and just get a governor's consent, because already that property has a C of O. So there won't be any need for you to duplicate a C of O on the same property. So what you just need to do is to apply for governor's consent with respect to the C of O on that property, just to inform the state who actually is the owner of the land, who has leased the property to the person who wants to sell for 99 years, and he wants to sell part of that 99 years to somebody else, just to inform the governor that, oh, this C of O that was issued to me, I want to transfer to some other person. So you just do a governor's consent on that. So it is transferable. So there is no title that is not transferable, being a registered court judgment on the land, being a certificate of occupancy, being a right of occupancy. All the titles I mentioned earlier, they are all transferable. It's just for you to do the needful, just to inform the state, who actually, by virtue of the provisions of the Land Use Act, is the owner of all lands in that state. Okay, so legal titles are very well transferable.
Earlier you said that all legal titles are valid.
Yeah.
So if they are valid, but do not have the same commercial value, why is there discrimination between some legal titles? For instance, a bank wants to give loan using the land as collateral. Why do we find this discrimination between certain legal titles, the demand for C of O as against some other titles?
Okay, so like I said, you don't necessarily need to have more than one title on a piece of land. Okay, just one will suffice. But let's take for instance, you got a legal interest or a legal right on a property as a result of a registered court judgment, for example. So there's nothing that stops you from proceeding to get another form of legal title on that property, that by by applying for the certificate of occupancy. Okay, so you can have more than one legal interest, more than one legal title on a particular property. So if you feel that, oh, because I want to obtain a loan and the only legal title I have on this property is a registered court judgment, which the bank may not accept to grant you the loan, you can proceed to get a certificate of occupancy on that same land that you have a registered court judgment, which is also a valid title on it.
Now let's talk about this issue of seeking the governor's consent. Why does it look like a camel passing through the eye of the needle? If you need to seek the consent of the governor, if you need for him to sign your CFO or get approval, why does it take years? And then how can technology be put in place to ensure that the process is transparent and efficient?
First of all, of course, we know that the governor of the state is a busy office. So if I don't want to believe that the governor will sit in the office to start doing consent on CO, of course, it is not. That duty has been delegated to some other persons to do that. But still, we still have this bureaucracy because we are not yet advanced. We've not gotten to that stage. I think technology is one of those areas we can actually use to improve and remove the bottlenecks that's usually involved in trying to get these legal titles. So we can use technology. I'm happy. The last time I visited the land registry at Alausa there, the land search is usually done electronically. In fact, they will tell you not to come there, that just register. If you are a lawyer, just use your practicing ID to just register. You have a pay ID, you register your pay ID, you just do it from your comfort zone. You know, just log into the portal. If you want to do a search, you do it. If you want to submit your documents to get governor's consent, you want to do CTC of these titles, you just do it from the comfort of your area, and that's all. So I think it's a right step in the right direction. So very soon, with the way Lagos State is moving with technology with respect to processing land titles, I think very soon we'll get to a point where you won't have to spend up to a year or two before you can get legal titles on your property.
I've seen situations where a person has documents showing that they own the land, yet the land comes under dispute. It goes to court and is awarded to the other party claiming ownership of that land. Are there titles under which a land cannot be disputed? Are there titles under which a land can be disputed?
Yeah, of course, just like I've said earlier, that the certificate of occupancy is the most valuable title you can have on a land. Now, however, there are instances where you see two persons presenting two different certificates of occupancy on a single landed property. So the question is, whose certificate of occupancy is authentic, is better than the other? So that is where the issue of, who actually obtained the certificate of occupancy first comes in. So of course, the court will look at, out of the two certificates of occupancy presented on a particular piece of land, which of them comes first. So whoever comes first, of course, is the genuine owner of that property. So the court will decide in that manner.
What about some documents? I've heard of community approval, the monarch's approval. All of this, what are they? Do they count?
Yes. The issue you used to have with a lot of people who purchase landed properties or purchase lands is that they don't know the distinction between titles to land and land documents. They are two different things, title to land and land documents. So when you're talking about titles, like I've said this morning, I've mentioned certificate of occupancy, governor's consent, excisions and gazette, registered court judgment, right of occupancy. These are all titles, legal titles, conferring legal titles to owners of such documents on that land. But when you're talking about land documents, you're talking about receipts, family receipt that will be issued to you when you purchase a land, okay? And you're talking about survey plan on the land. And in fact, it's so funny that people will think that survey plan, once you do survey plan, you have a genuine title to a land. In fact, those people are getting it wrong because a survey plan is just a land document, okay? Then you have a deed of assignment that is not registered, is just a land document. You see some people, when they purchase a land, they will call a lawyer to do a deed of assignment and it ends there without perfection. What you have is just a land document and not a title to that land, okay? So then you also have contract of sale documents. It's also example of land documents. Okay, so these are, if the approval you said, they are just land documents.
Community approval, the monarch's approval.
These are just land documents. It does not confer any legal title whatsoever on whoever has that document.
Now let's talk about this issue of lands that are under acquisition.
Yeah.
You hear that a lot, and can you apply for legal title on a land that is under acquisition?
Yes. By virtue of the provisions of the Land Use Act of 1978, of course, we know the status of lands, that all lands in the state belongs to the state government. And what the government can only do is to lease out to individuals, groups, companies for 99 years, okay? So, practically, by virtue of the provisions of the Land Use Act, most lands are under government acquisition and control, except the government returns it back to the indigenous owners. Okay, so which means for if most properties, most land are under government acquisition and control. So that's the reason why it is usually advisable that you should get a C of O on those properties, so that by the time the state calls back their property, you will be entitled to compensation because you have legal title on that property, even though the land belongs to the state.
Saying that CFO is the king of land titles,
yes.
Now what can be done to reduce the percentage of land without that legal title? Because there seems to be a great relationship between the title that you have and the commercial value of that land.
Yes. That is where the issue of enlightenment comes in, and most persons who have intention of purchasing land, they are illiterate in the sense, I don't mean that illiterate not going to school, they are illiterate when it comes to issues of lands. They don't want to consult a lawyer before they proceed to buy lands, and at the end of the day they fall into issues that will lead to litigation, spend so much time, energy, resources, even more than the money you spent in buying that land, okay? So, the issue of literacy is very important. People need to be informed. People need to be enlightened. People need to be educated on what it entails to get a valid title to a land, a valid legal interest and title to a land. You don't just buy a land and you don't do the perfection, getting the C of O. Okay, you don't just buy a land and there's a C of O on it, and you believe that that C of O covers your interest without getting the governor's consent. If you have a C of O that was transferred to you and there's no governor's consent with effect to that C of O, you don't have a title. That title still remains with the person that sold to you. So the person can come tomorrow and start laying claims on that property that property belongs to me. I never sold it to you. You know, so these are issues. People who go into properties, real estate, buying lands and landed properties, they need to be informed what are the various kinds of title you can get on a land and the process involved in getting these titles.
Now, taking a clue from the experience you've had with some of your clients, what are other mistakes or error people make when they need to acquire landed properties, especially when it's just from one person to the other, not from a government agency this time around, especially from one individual to another individual? What are these common mistakes people make, and then what are the due diligence that they are supposed to do to ensure that you have the right documents?
The first thing is, if you want to buy a land and you are not a lawyer, the first thing I expect you to do is to consult a lawyer. Oh, I want to buy this land. Can you help me do a due diligence? Now, due diligence involves stages. So the first stage has to do with doing a search on that land. So you want to know what is the title the land has. So once you're able to get the title that the land has from the vendor who wants to sell, you take that title to the land registry to search if there are any encumbrances on that land or there are any disputes on that land. That's the first thing. So once you're able to clear that, then you move to the next stage. So the next stage will be for you to go and inspect the land to see it physically for yourself. Okay, so once you do that, then the next stage is you now start negotiating for the purchase price. Of course, purchase price depends on the value of purchase price depends on the kind of title that land has. A land that has a C of O, of course, it's going to be expensive, because it's a legal interest, and C of O is the most valuable type of title one can have on a land. So once you make the part payment with respect to that property, you draw up a contract of sale. And the contract of sale will state that the time within which you're supposed to pay the remaining balance. So within that period, the vendor is supposed to deduce the titles he has on the land to the lawyer or to the purchaser to verify and all. So once it is verified and you see, okay, this title is perfect, then you pay the balance of the purchase price. Then the lawyer to the purchaser comes up with a deed of assignment. It's executed between the parties. Then he must perfect the deed of assignment. Perfect the deed of assignment. I mean, if the land has a C of O, you get the CTC of the C of O at the land registry, you do the governor's consent, you do the registration, you do the stamping. Then once you're done with the governor's consent, you do the CTC of the governor's consent. It's as simple as that.
Now let's look at the place of different parties or different authorities, so to speak, when it comes to land. So in areas where you have the community selling land, you have agents selling land, and they're to give you certain documents. Talking about the community, for instance, you have instances where they call for verification, time upon time. Does the community have the power to be carrying out verification of land ownership, maybe a year after the lands have been sold, 2 years after the lands have been sold, even several years after the lands have been sold but not developed? What is the right of the initial landowners over the land after it's been sold?
Yes, I didn't mention as part of the titles or the legal interest you can have or legal titles you can have on land, we have what is actually known as a freehold interest. Now, this freehold interest is what is usually prevalent in areas like Ekpe, where the lands are majorly owned by the indigenous people of Ekpe. So in that instance, what it means is that the land is not under the control of the government. Okay, it's not under the control of the government. So what's in that case, if the community, if the land was sold by the family members or members of the community in that area, they have rights to do this, once in a while, review of a title or whatever, So, but what I always advise people that if you buy a land from, let's say, for example, under a freehold interest, it is usually advisable because you can't override the provisions of the Land Use Act that still says that all lands belongs to the state, irrespective of whether that land is, the interest you have on that land is a freehold interest. That is, it belongs to the community and the government does not have control over it. Because one day, the government will come and exercise the provisions of the Land Use Act and take that land away from the community, and only those persons who have C of O on that land will be entitled to compensation. So I always tell people that if you buy land and the interest you have on that land is, the legal interest you have on that land is a freehold interest. So it's always advisable that you do a C of O on that land so that anytime government, invokes the provisions of the Land Use Act to collect the land, you'll be safe and you get a compensation because you have the certificate of occupancy, which shows that the government has leased that land to you. And if they want to take it from you before the expiration of 99 years, they have to compensate you.
When talking about land matters, definitely we can but talk about the activities of the Omoniles, what is known as land grabbers.
Yes.
They are gradually becoming forces to reckon with. They are like necessary devils, if I may put it that way. And it's looking like they are holding the state to ransom. Is there anything that can be done to control the activities of land grabbers?
I think the Lagos state government established an agency that has to do with land grabbing agency. So, and I think one of the initiative of that agency is to disrupt any area in Lagos where land grabbing is prevalent. I think that agency came up during the time of Fashola's administration. That was when that agency came up, and that agency have been doing well in trying to ensure that there are no issues of land grabbing in Lagos State. Even as local, when I say local as Ekpe is, I don't think that there are issues of land grabbing there because I still went there to do a due diligence on the property which a real estate company from the UK wants to invest in, and there was nothing like land grabbing. Even up to the time that the person bought the land and did the perimeter fencing, there was no issue of giving Omalile 50,000 or 100,000 to be able to work on that piece of land. And it's inside in Ekpe. So.
But it's not widespread. That may just be an area where such issues are not seen. But across different states and in different areas, you still find this. It's almost like it's the regular thing to do, or it's been institutionalized. That once you're developing a land, these are the people to settle, and there is nothing you can do. You can't get the police involved. You can't. It's just as if, pay them, they must collect this.
Yes.
It's an informal tax,
yes.
kind of.
Yes. What I'm saying is that in Lagos, it is not prevalent because of the land grabbing agency established by the Lagos to curb the issues of land grabbing. These things are usually prevalent in places that are outside Lagos, very close to Lagos. I think, Ogun State, for example, is very prevalent there. So it shares borders with Lagos. But in terms of Lagos, I don't think that anybody will come out and say he's a land grabber. Of course, you'll be arrested and you'll be prosecuted.
Could it be as a result of the existing laws against the activities of
land grabbers? Which
and how often has people, taken advantage of that law?
Yes, of course. A lot of people, like I said, are not literate when it comes to land matters. When it comes to land matter, a lot of people don't know that there's an agency that has to do with that. There's an agency that was set up by the government, Lagos State government, to curb land grabbing. A lot of people don't know that. A lot of people live in the fear that if I don't give these people money, they will not allow me to do my job. After all, how much is the money they're asking for? Let me just give them and let them not disturb my job. They don't know that if these people get arrested, they could be prosecuted.
So, For the commercialization of a property that doesn't have CFO or when one needs that for bank purposes, in absence of the CFO, what kind of title can substitute and still will be recognized or accepted?
It depends on what the bank wants. I'm not a banker anyway, but I know that most mortgages are usually legal mortgages. Most mortgages that banks usually want, usually legal mortgages. That is, you are presenting a title document that is a legal document. So, but I know that most banks always prefer the C of O because, you know, it's the most valuable legal title you can have.
It can be disputed.
It can be disputed. So, but some banks can also take some other ones, like I've mentioned. They can take some other ones, like I've mentioned, annexation or gazette. Of course, they can take that. They can take a registered court judgment as the title that you have on the land, or even freehold, even deed of assignments if it's perfected. You know, so it depends on what the bank sees as their requirements. Every bank have their own requirements as regards to the kind of legal documents you must deposit to be able to get loans from them. So.
All right, let's wrap up. We're out of time, but let's wrap up with these. What do you think people should do, or the Lagos State government should do, looking at this staggering number of defaulters when it comes to legal titles? What can be done to correct this kind of development so that at least they'll be better informed and these defaulters will reduce over time? If you have 94% in Lagos, that's quite disturbing.
Yeah, quite disturbing. Well, the truth of the matter is that nobody wants to queue at the land registry for 3-4 hours because you want to perfect your title to a land, except it's very urgent. Except it is very urgent. We all have our places to go to work, you know, except it is very urgent. So the first thing is for the government to cut the bureaucratic process it takes to get these titles, which they are working on, you know, the online, you know, registration, online search, online lodging of documents, you know, that's a good step in the right direction. So once they're able to do that, to cut the bureaucracies involved in obtaining these legal titles to lands, then the next thing is to inform, sensitize these people on the need to get legal titles to document to their lands, so that when there are issues that has to do with litigation, of course, they will be saved by that. Or where there are issues of compulsory acquisition, they'll be saved by that. So,
finally, how expensive is it to get some of these titles, particularly CFO?
Well, somebody asked me that question yesterday, and I told the person, you can't really say. You know, these things are administrative. Of course, on paper, it looks very, very small, the amount you're going to spend in getting these titles, but you know, you have to shock a lot of people to be able to get this thing out.
Real shocking.
Yes, shock a lot of people, yes. You know what I mean by shocking a lot of people. You know, for example, ordinarily, if you want to get the CTC for a title, it's not more than 5,625 naira, but
on paper.
Yes, but you might end up spending like 15,000 because you are shocking one or two persons to help you to do it and let it come out on time. To fast track the process. So ordinarily, on paper, it doesn't cost much, but
in
let's
reality,
just leave it at there.
You may need to agree sometimes or go through
go
through a distance.
Go as far as telling you that you have to cook rice for them when they are coming to come and inspect the land. I mean, from the ministry, you can imagine. But let's just leave it at there.
All right, we hope that the process in acquiring legal titles for land is harmonized and made as seamless as possible. And it comes out, the CFO or whatever titles that the landowners may be chasing comes out in quick time. Because people buy lands for different reasons. For some, they want to develop the land. For some, they also want to resell or do business with it. It's some money that has gotten into the acquisition of the land. It should be something that those who have invested should be able to recoup in good time. Thank you so much, Victor Jibunoh Esquire, who is a lawyer in Lagos, and that's why he's been able to talk extensively about the issues around legal titles of land in Lagos. He's also managing partner and head of corporate commercial and general legal services, OPTIX Legal Consulting. We thank you for your time on Early Exchange today, and the lecture you've given to landowners and those who intend to buy lands in Lagos, how to go about acquiring titles for their land.
Early Exchange, shaping policy, advancing development.